An Employment Law Guide. Chapter 1. An Employment Law Guide. Employment Labor Job Law. The intent of most laws is supposedly to protect workers from unscrupulous company practices. However, some are bad for business, such as all the regulations trying to stop illegal aliens from working. They do the jobs other people don't want to do. We should be thankful for at least some of them. Not many people want to work in slaughterhouses or pick fruits and vegetables in the fields. Laws in the workplace generally follow company size. The larger your company, the more the laws you have to follow. Some of the workplace laws that apply to all companies with at least one employee are federal and state wage. Federally, they are regulated by the Fair Labor Standards Act/FLSA, enforced by the U.S. Department of Labor's Wage and Hour Division, DOL.gov. Hourly wage laws, U.S. Department of Labor Wage and Hour Division. Immigration and Nationality Act prohibits employers from discriminating on the basis of citizenship or ethnic origin. The Equal Pay Act requires all employers to provide equal pay for equal work, regardless of sex. Child labor laws. The general law is that before hiring a minor, you need to get a work permit from state and/or federal authorities. Harassment laws generally include sexual harassment, gender harassment, harassment based on disability, medical condition, race, pregnancy, or childbirth. Unemployment and disability insurance, state and federal laws require virtually all employers to provide this service to employees. The Federal Immigration Reform and Control Act of 1986, IRCA, is meant to ensure that American companies employ only persons who have the legal right to work in the United States. Form I-9 must be completed for every employee hired after November 6, 1986. Posting and notice requirements. Employers have to post general information regarding sexual harassment, workmen's compensation, etc. by providing pamphlets, posters, etc. Time off rules. There are a few civic duties that employers must give employees time off for, like voting, jury duty, military service, volunteer firefighting, etc. Occupational Safety and Health Laws, Federal, OSHA.gov. Uniformed Services Employment and Re-Employment Rights Act, USRRA, of 1994, this law helps ex-military people find civilian jobs. Some of the workplace laws that apply to all companies with at least 15 employees are Americans with Disabilities Act/ADA requires that employers make reasonable accommodations to qualified individuals with disabilities who are either job applicants or employees. Title VII of the Civil Rights Act of 1964 bars discrimination by employers on the basis of race, color, religion, sex, or national origin. Pregnancy Discrimination Act, 1978, can't discriminate against pregnant women if they're able to do their job duties. Americans with Disabilities Act, 1990, based on the Civil Rights Act of 1964 and Title V of the Rehabilitation Act, USDOJ.gov CRT/ADA, 800-669. 4000. Some of the workplace laws that apply to all companies with at least 20 employees are Age Discrimination in Employment Act, 1967, for older folks, over 40. Consolidated Omnibus Budget Reconciliation Act of 1985/COBRA, for companies with 20 or more employees. If employee leaves the company, he can stay on the company health insurance plan for 18 months at his own expense. Some of the workplace laws that apply to all companies with at least 50 employees are Affirmative Action Plans. Companies with 50 or employees and at least $50,000 in government contracts must have an affirmative action plan. Family and Medical Leave Act, 1993, for companies with 50 or more employees, unpaid leave up to 12 weeks to tend to family situations. Worker Adjustment and Retraining Notification Act/WARN Act applies to companies with 100 plus employees. Employers must notify them 60 days before a layoff and offer other compensations like retraining into another career. Some other employment-related laws are as follows. Electronic Communications Privacy Act doesn't cover employees in the course of business. In general, the employer has the right to monitor employees visually with cameras and their communications to phone, fax, email, internet. National Labor Relations Act, Labor Management Relations Act aka the Taft-Hartley Act gives employees the right to organize and form a union or any manner of a collective bargaining group. Rehabilitation Act of 1973, prohibits discrimination against disabled individuals by all programs or agencies receiving federal funding. Vietnam-era Readjustment Assistance Act of 1974 requires government contractors to take affirmative action to hire disabled Vietnam vets. A list of employee rights. The following information is general. Books about employee rights are at hashtag 331.01109 or HD 6971 at the library. Go to hashtag 344.71-73 or K3247 and KF345, Labor Laws, of the library and the Government Documents section for more specific information. The main legislation dealing with employment in the United States are Age Discrimination Employment Act/ADEA, involuntary retirement, firing, or not hiring people because of advanced age. Americans with Disabilities Act. Cash or Deferred Arrangement/CODA, 401k. Civil Rights Act, Title VII, Employee Discrimination, Racial, Sex, National Origin, Religious, Smoking, Sexual Harassment. Civil Rights Act in general. COBRA for continuing health coverage after termination. Electronic Communications Privacy Act. Employee Retirement Income Security Act/Erisa, pensions and fringe benefits. Retirement Equity Act, gives divorced and widowed spouses access to pension benefits. Equal Employment Opportunity Commission/EEOC. Equal Pay Act, sex discrimination. Fair Labor Standards Act, minimum wage. Family and Medical Leave Act/FMLA. Federal Unemployment Tax Act. Labor Management Relations Act, the right to organize and form unions. Occupational Safety and Health Act. Older Workers Benefit Protection Act/OUTPA. Pregnancy Discrimination Act. Privacy for Consumers and Workers Act, surveillance. Qualified Domestic Relations Order/QDRO, relates to divorce and pensions. Rehabilitation Act, disabled people. Retirement Equity Act, divorced spouses or widows entitled to spouses' pension benefits. Revenue Reconciliation Act. Unemployment benefits. Worker Adjustment Retraining and Notice Act/WARN, for workers of plants that shut down. Workers' compensation, etc. The biggest issue these days is job security. A lot of employers get around the laws by hiring disposable workers, usually part-timers, temps or contract workers so that they're not legally bound to provide them with benefits nor job security. While these options have some advantages for the freelancer not particularly interested in a full-time career, they nevertheless cut down on the opportunities for good, secure jobs, so you have to accept this fact of life as the wave of the future, that the days of the one-company job where you stay for your entire career at the same place and get a pension are very much in a minority now. Don't count on it. Look to be flexible and current in the work you do. If you're in a company pension plan, you should get a summary plan description/SPD which describes all the details. This is the legal document which the company must adhere to, otherwise you can sue them. The Employee Retirement Income Security Act/ERISA covers company pensions and fringe benefits. One of the fringe benefits is health insurance, which is probably the area with the most problems between employees and management. Get your employer's paperwork on the health insurance they offer you and refer to ERISA for an explanation of the law if you run into any legal snags. If you have AIDS, the laws are even more complex. The most common problems in the hiring process are that the employee lies on the application, which are grounds for termination or not hiring you, and the employer misrepresents the terms of employment. Employers aren't allowed to ask you personal questions not relevant to the job. If they do and you choose not to answer, they probably won't give you the job because they don't like your attitude. You could sue them, but they could always say they found somebody better, so your best bet when asked personal questions is to just play along with the guy, act like a bud and you're having a regular conversation. As far as the tests employers can give you, it has to be related to the job, a test that predicts your ability to do the job, not an unrelated test which they can use to screen out all the people they don't particularly want to work there. Employers lie to employees, promising them a lot of things to work there then not delivering. If it's a direct lie and not just flattery, you can sue them civilly. Clear up all job details you're not sure about. Get it in writing in your employment contract to keep it all legal and out in the open. Your best bet before you take a job is to read through the employer's rule book and or ask relevant questions. For legal reasons, make sure you understand all the terms of employment before taking a job. Read your employment contract carefully. If the employer tells you will make an outrageous salary for working for his company, like $100,000 in commissions, and you don't, it's misrepresentation. If you decide to sue an employer based on misrepresentation, it will be very difficult to prove. Your employer can check your background and credit history and request that you take psychological tests as part of the application process. Under the Fair Credit Reporting Act, the employer must get your authorization before he checks your credit history out. If job performance is related to medical health, your employer can make you take a medical exam. Before you take a job, you should read the employment contract thoroughly to know exactly what you're getting into. If you want changes, get it in writing. You have many rights in the workplace, including your basic civil rights. You have the right to start a union, to join a union and vote in union elections without management interference. If an employer misrepresents how much you can / will earn, you have grounds to sue him. If you work overtime in most jobs, which means over 40 hours a week, you are legally entitled to time and a half, except for white-collar jobs because they basically earn a high enough salary. You have constitutional protections from the invasion of privacy into your personal life in matters not relating to work. A company is allowed to have a reasonable dress code. Some states have regulations regarding genetic testing at work. There's a federal law that protects federal workers from being tested genetically. Genetic/DNA testing is a test an employer might use to see if you have a certain gene that predisposes you to catch certain diseases, so that if you catch that certain disease, it can't be blamed on your work and your employer doesn't have to pay you benefits. The EEOC has already filed several lawsuits against companies who've conducted such tests because they deceived their employees by not telling them they were doing DNA tests on them when they had the company doctor draw their blood, and also because genetic predisposition is a very weak science as to what actually causes diseases. The way you live your life and what you do at work could play a much larger role than genetic predisposition. If you see an unsafe condition at your workplace, report it to your boss and give him a chance to correct it. If he doesn't, you legally have the right to report him to the local branch of the Occupational Safety and Health Administration, OSHA, without fear of retribution. The Fair Labor Standards Act 29 U.S.C. regulates minimum wages, contract workers, temporary workers, part-time work, overtime, and equitable pay standards for men and women. If employers want to fire you, they will look for a reason like fraud on your resume. Employers have the legal right to give tests which measure the qualifications for the job, and that's basically it. Some jobs require medical tests, others don't. If they're used, it's grounds for discrimination if the list to weed out disabled people. Some companies do genetic testing, and if they identify defective genes which predispose you to get a major disease, they either might not hire you, or if you're an employee, they will try to deny medical coverage based on that. The employer has an obligation to tell the employee the truth in hiring rule. He can't hire somebody with idle promises and not deliver, like the guy who relocated and was let go after 6 months only to sue and win. To keep everything clear, get employment details as specific as possible in writing. Employers are responsible to collect money from the employee's paycheck for unemployment compensation, Federal Unemployment Tax Act/FUTA, and Social Security/FICA. The most common types of discrimination are racial, place of origin, language, sex, sexual orientation, religion, smoker, pregnancy, age, disabilities, AIDS/HIV. You have privacy rights. Even though the Drug-Free Workplace Act encourages companies with federal government contracts to keep drugs out of the workplace, you're generally not allowed to be tested unless the job has some element of safety hazards in it, like people who operate transportation vehicles, planes, trains, ships, trucks, etc., as covered by the Omnibus Transportation Employee Testing Act. The Employee Polygraph Protection Act renders the lie detector virtually useless in the workplace. It is generally allowed only in criminal investigations. Books about employee rights are at hashtag 331.011 or HD 6971 at the library. Chapter 2. Employment Law and Job Regulation Websites. Employment Labor Law Job Regulation Websites 1. Books about personnel management are at hashtag 650.13, 658.406 and he 736 or HF 5548 at the library. Try hashtag 658.311 or HF 5549.5 at the library for books dealing with employment law and related issues. Go to the American Management Association's website amicobooks.com for books about the subject. shrm.org/law/state/toc.asp. shrm.org/law/state/alabama-toc.asp. shrm.org/law/state/New Jersey-toc.asp. abanit.org/disability, mental and physical disability law. abanit.org/labor/home.html. aclu.org/issues/workers/HMWR, workplace rights. act.org/WWM, world of work. allexperts.com/q/employment-law-924. bartleby.com/65/law/labor-law.html. blog.laborlawcenter.com. business.com. civilrights.org. constructionweblinks.com, laws and regulations industry, by state. cpwr.com, Center to Protect Workers' Rights. aridlc.com/index.cfm ? Fuse action =HR laws, employment law resources, certifications, courses, and continuing education. duim.org/legal resources/employment labor law.aspx. eeoc.gov, Equal Employment Opportunity Law. eeoc.gov, U.S. Equal Employment Opportunity Commission. eeoc.gov/employees, equal pay and discrimination compensation. eeoc.gov/facts/qenda.html, discrimination, EEO, federal laws prohibiting. eeolaw.com, Equal Employment Opportunity Laws. lnfonet.com, Employment Law Articles. employerlawreport.com. employersinc.com, Employers Association Inc. of Minnesota. employerslawyer.blogspot.com. employment.findlaw.com. employmentblawg.com, Labor and Employment Law, Human Resources and Other Work. employmentguide.com. employment-law.freeadvice.com. employmentlaw360.com. employmentlawalliance.com. employmentlawforum.com. Employment Labor Law Job Regulation Websites 2. en.wikipedia.org/wiki/federal_employees_health_benefit_plan. en.wikipedia.org/wiki/hofstra_labor_and_employment_law_journal. en.wikipedia.org/wiki/job_creation_and_assistance_act_of_2002. un.com/articles/faq.htm, frequently asked questions about employee relations, access to personnel files, jury duty, severance pay and monitoring email. findlaw.com/01topics/27 labor. hofstra.edu/academics/law/labor-law.cfm, Hofstra Labor and Employment Law Journal. hrhero.com. hrlawindex.com. ideasandtraining.com/employment-law-training.html. laborandemploymentLawblog.com. laborlawcenter.com. laborlawtalk.com. law.com/jsp/pc/emplaw.jsp. law.com/professional/emplaw.html. law.cornell.edu/topics/employment.html. laborlawtalk.com. nalc.org/migrant/english/index.html, Guide to Labor and Employment Laws for Migrant Workers in North America, Commission for Labor Cooperation. nela.org, National Employment Lawyers Association. nalo.com/legal-encyclopedia/workplace-rights, Nalo's Legal Encyclopedia. nalo.nalo.com/legal-encyclopedia/hr-employment-law, employment rights. nrtw.org, National Right to Work Legal Defense Foundation. statutes.law.cornell.edu/topics/employment.html, employment law, an overview. straylight.law.cornell.edu/topics/labor.html stu.findlaw.com/journal/labor.html. U.S. Department of Labor Compliance websites. dol.gov, Department of Labor, US. dol.gov dol.gov/compliance, Department of Labor's Compliance Assistance. dol.gov/compliance/laws/comp-fmla.htm, Family and Medical Leave Act. dol.gov/dole/audience/aud-workers.htm, Workers Information, US Department of Labor. dol.gov/dole/compliance/compliance-major law, major laws. dol.gov/dole/topic/discrimination/ethnic-disc.htm, sexual and ethnic discrimination. dol.gov/dole/topic/youth labor, youth and labor, dole. dol.gov/ebss/compliance_assistance.html. dol.gov/e-laws, employment laws. dol.gov/ESA, Employment Standards Administration. dol.gov/ESA/contacts/state_of.htm. dol.gov/WHD/state/state.htm, State Labor Laws. deolata.gov/oa/eta_default.cfm, Employment and Training Administration. California Labor Law websites. calaborlaw.com, California Labor and Employment Law. calchamber.com/california-law/pages/california-employment-law.aspx, California Employment Law. californialaborlaw.info. dir.ca.gov/dlse/dlse-laws.html, research the Labor Code, California. Working conditions/worker rights websites. dol.gov dol.gov/pwba, Pension and Welfare Benefits Administration. dole.gov/dole/esa/public/oak.org.htm, Workers' Compensation. dol.gov/dole/esa/public/whd.org.htm, Wage and Hour Division. en.wikipedia.org/wiki/right_to_work. en.wikipedia.org/wiki/right-to-work_law. wageweb.com. Business and Legal Reports Incorporated. blr.com. Books about legal issues at work like family and medical leave compliancy. Family and Work Institute. FamiliesAndWork.inst.org. FamiliesAndWork.org. National Adoption Center. Adopt.org free booklet, The Employer's Guide to Adoption. Minimum wage websites. en.wikipedia.org/wiki/minimum_wage. dol.gov/whd/FLSA, minimum wage. dol.gov/ESA/minwage/America.htm, minimum wage in the states. Child labor law websites. dol.gov/compliance/guide/childlbr.htm, child labor laws. Canadian employment law websites. blog.toronto-employmentlawyer.com, canadaemploymentlaw.com, canadalegal.com, canada1.com/ezine/feb02/employment_law.html, canadianattorneys.net, canadianemploymentlaw.com, canadianemploymentlawyer.com, canadianhrreporter.com, canadianinstitute.com/human/employment_law.htm, canadianlawsite.ca/employment.htm, canadian-lawyers.ca, cch.ca/business.aspx?tid=79, Canadian Employment Law Guide. clbonline.ca/html/publications.html, clc-ctc.ca, Canadian Labour Congress, clrd.ca, Canadian Legal Directory, duim.org/legal resources/employment-labor-law.aspx, employmentlawtoday.com, Canadian Employment Law Today newsletter, en.wikipedia.org/wiki/Canadian_labor_and_employment_law, firstreference.com, Canadian Payroll and Employment Law, hrinfodesk.com, hrmguide.net/Canada/law, hrreporter.com, Canadian HR Reporter, hrsdc.gc.ca/eng/lp/sblaw/clli/eslc/01 employment_standards_in_Canada.sh.tml, kentemploymentlaw.com, British Columbia, mycanadianemploymentlaw.com, osler.com/resources.aspx, Canadian business law firm, unpaidovertime.ca, if you worked unpaid overtime, class action lawsuit, wrongful dismissal.ca. Chapter 3. An Employment Lawyer Guide. The National Employment Lawyers Association. The National Employment Lawyers Association. 44, Montgomery Street No. 2080. San Francisco, California, 94104. 415-296-7629. NELA.org. Provides a locator for employment lawyers. Employment lawyer websites. abanet.org/labor/home.html. allexperts.com/q/employment-law-924. attorneypages.com/530. azaminathan.com/about.html, law firm, California. carmetch.com/discrimination.html, Georgia employment and labor law firm. carmetch.com, Georgia employment and labor law firm. discriminationattorney.com, California employment attorney. los-ilk.org, the Legal Aid Society Employment Law Center. emplawyernet.com. employerdefense.com. employerslawyer.blogspot.com. employmentattorneylosangeles.com. girossman.com. Legal advice in employment and labor law issues, wrongful dismissal cases, employment contracts, and human rights. employmentlawalliance.com. employmentlawfirms.com. employmentlawgroup.net, Washington, D.C. civil rights attorney. garfinkeltrialgroup.com, law firm, Orlando. getareferral.com, California labor lawyers. labor-employment-law.lawyers.com. employmentlawgroup.net, Washington, D.C. civil rights attorney. mggbgs.com, law firm, Washington, D.C. A list of top labor employment law firms, no websites. Aiken Gump Strauss Hauer and Feld LLP. Baker and McKenzie. Epstein Becker and Green, P.C. Fisher and Phillips LLP. Gibson, Dunn and Crutcher LLP. Jackson Lewis P.C. Jones Day. Littler Mendelson P.C. Morgan Lewis and Bacchius LLP. Ogletree, Deakins, Nash, Smoke and Stewart, P.C. Orick, Harrington and Sutcliffe LLP. Paul Hastings LLP. Proskauer Rose LLP. Seyfarth-Shaw LLP. Skadden, ARPs, Slate, Meager and Flum LLP and Affiliates. Labor and Employment Dispute Law Firms. Littler Mendelson P.C. Morgan Lewis and Bacchius LLP. Paul Hastings Janofsky and Walker LLP. Chapter 4. Personal Evaluation Report/PERS. Personal Evaluation Report/PERS. The conventional view is that regular PERS/performance evaluation reports are good. They are reports on your employees where they read about what you think of their work and talk to about it if they want. Some people say employees want feedback as to how they're doing. It's probably best to ask employees how they think they're doing, ask them what their weaknesses are, tell them what you think about their performance and chart a course for the future. Personal evaluation reports/PERS have become a steady staple in virtually all corporations. Generally, they're like the report card you had in school in the younger grades. There are 20 or so attributes that your immediate supervisor grades you on, things like: takes initiative, is a good leader, takes instruction well, is a team player, is punctual, comes to work on time. In addition to this, the supervisor writes out a few paragraphs of your performance as he or she sees it. The underlying assumption is that you and the company have a contract/plan that you're trying to do your job better so they can promote you and otherwise move you up. If you don't fit this plan, you will get a bad PER. With some PERS, they have a component called peer assessments where everybody has to rate everybody else on 20 attributes or so. In some companies, you are assigned a number grade for every attribute your supervisor grades you on, then given a final score which the company posts publicly because they think that this competition for high PERS is a good thing, but I tend to think it creates an aura of phoniness, people acting like someone they're not just to get high PERS, but it works so I shouldn't be too critical. Performance reviews are a regular, ongoing process part of most corporate functions. Managers should schedule a regular period for them once or twice a year, like the first week of June and the first week of January. The purpose is supposed to be to examine an individual's performance and progress relative to goals or expectations set by him or her and the manager during the last performance review. Although everybody I know hates performance reviews, the HR people say it has several benefits, like: the manager and employee meet face to face at least once or twice a year. It's a chance to air grievances on both sides and come to some kind of meeting of the minds. It helps the manager identify problems employees might have and set on a course to correct the. It also helps identify problem employees who might have to be eliminated. The tone is specific. Each side can say what's on their minds rather than passing in the hall and the boss saying you're doing a good job. The performance review helps set goals for the future to help guide the individual. Good employees need to be told they're good. Bad employees either need to be helped or identified and terminated. If you decide to go with performance reviews, be professional and thorough about it. Have your standard performance objective sheet which lists 20 or more characteristics that the immediate superior grades the employee on plus the written report. It helps if you have read it beforehand and have written down a few statements or questions. In general, your direct supervisor calls everyone in one by one and asks you how you feel about your progress, questions you about your weaknesses, etc. From that, he gets a feel of your headspace and uses his own opinion to write out your PER, which he will often pass on to his boss, who then interviews all the underlings one by one even if he doesn't know them and talks to them based on what he reads in the PER. The employee walks in, sits down. You give him his average score on the sheet. If it's graded 1 to 5, 3 means you met the standard. Let him read what his underling boss wrote up about him, then talk to him about his weaknesses or strengths. He signs the PER and you both come to a tacit agreement that he will try to improve in some area or might be promoted if he keeps it up, etc. Then he leaves and the next guy comes in. I knew one guy who was responsible for conducting 60 PERs twice a year. It can take away time from doing real work, but the HR guys will say it serves a valuable function. Some common PER topics are: what did you achieve? What are your objectives? What obstacles prevent you from achieving your goals? How can I help you get ahead, improve your performance? What training do you need/want and how can I help you get it? Are you happy or do you want another position or a promotion? What is your future plan with the company? Be specific when talking to the employee. Don't beat around the bush. Tell him what he's good at, what he's bad at and where to go from here. Get feedback from him and a verbal statement so that you can verify that he understands what his issues are and that he says he will try to do better from his own lips. Set future objectives for the individual. If the employee wants training to advance in his job or needs substance abuse treatment, help him out with these things. When you have an employee with a PER, tell him what he's doing wrong, then tell him you will talk to him once a week for a while to see how's he doing, re-evaluate him and get feedback. Document all his infractions. Keep talking to him about it. If he doesn't get better, escalate it up to probation, then a final warning. Get rid of him if it keeps up. Try to talk to problem employees to find out what their problem is or what's really eating them. They may be having personal problems unrelated to work that's interfering with their performance. Try to help them heal whatever's eating them and do better on the job. If a manager uses his evaluation of your work performance to get back at you, if you can get people stand up for you in court, you can dispute his evaluation and sue him. Try hashtag 658.3113125 or HF5449 to HF5549 at the library. Personal Evaluation Report/PERS, Anti-View. Personally, I feel the HR people like PERS because it's part of their job, so they're going to do what they can to protect them, but overall I'm of the mind of letting an object in motion go if it's going in a straight line, which means you don't do PERS if you don't need them. It's kind of like if it's not broken, don't fix it. If some guy has been doing a steady job for the past 20 years, what does he need PERS for? They piss him off and waste your time. Even though some companies have peer assessments where everyone rates their colleagues usually on about 20 criteria on a scale of 1 to 5, even if you barely know them, I don't like them because they're often a popularity contest and too personal. You're not really judging your coworker's work ability. You're judging how much you like or dislike the person. It makes the workplace phony. Some bosses go around asking each worker about his coworkers. This is generally stupid because people will inject their own personal biases into the equation, bring up gossipy items, and it's not very reliable anyway, because when you ask someone about someone else face to face, most people simply give a bland, whitewashed, generic answer, so what? You only do them for the people who need a formal warning or probationary period. Everybody else just keeps working as normal. If you have a problem with anyone, you tell them when and as required. There are generally 8 major arguments against PERS. 1. They are artificial and stilted. They predispose that twice a year a boss will write up a report on an employee and go through a song and dance about it, often suggesting he try harder or pat him on the back for a job well done. If it's broken, don't fix it. If employee X has been driving a bread truck for the past 20 years or manager Y has been doing his dinky little administrative job at his level of the Peter Principle, comfortable that he has reached his level where any more responsibility would mean incompetence on his part, and everything is running as smoothly as any bureaucracy could, why bother with PERS? Life is more immediate and spiritual. Many employers don't like the idea of PERS because they don't want to confront employees with negative criticism, so a lot of them rationalize that as long as the job gets done, who cares? Who needs the hassles? I generally tend to agree. Life at the workplace to me should be a right now thing. If someone is screwing up, you take them aside and talk to them. Give them a few chances, then tell them they aren't up to standards so they have to go. This approach usually works with sensible people, but in our litigious society, employees are suing corporations left and right for wrongful termination, which is probably the real reason for PERS. It leaves a paper trail, plus the fact that the HR crew want to feel that their profession matters and perpetuate their jobs, so they will always hype up the PER process. 2. PERS waste a lot of time. In order to write reports on 20 employees or so, then interview them all one by one takes time away from the real job, production. If an employee is doing a functional job, leave him be. If he's screwing up, that's the time to pull him aside and write up a formal report and start going through a process. Conversely, if he's doing a good job, pat him on the back. Otherwise, let sleeping dogs lie. It's all about real conversation with employees when and as required, not stilted PERS. Have a coaching/mentoring program in place where a senior guy takes a junior guy under his wing and develops as he goes along with the need for PERS, just a comment to the boss that he's either cutting it or he isn't. 3. PERS are generally not about workability. They're about popularity or how much the boss likes the worker, as opposed to how good that worker is in an objective sense, so it's an exercise in futility where nothing productive gets done. Try to hire workers you can relate to in the first place, but barring that, keep the relationship focused on work performance and leave your personal feelings and the personal relationship part of the relationship out of it. 4. PERS are demeaning. They send a message to the workers that we control you, and a lot of the bosses don't like the role of having to dissect an employee, especially if it's a technical field like engineering where technical results is all that matters, and if they've been working side by side with the guy on some project. 5. PERS by their very nature imply a low trust of employees, by having formal written reports about them constantly. 6. In an era of propaganda about teamwork and horizontal leadership, PERS destroy this attempt at a more personable, cooperative relationship between workers and management by creating this rift with the superior boss on one side evaluating the lowly employee. 7. The PER is a sacred cow so deeply entrenched as an automatic part of our business culture that many managers would feel lost within them or feel like they're violating a great commandment of how to be successful in business according to what they learned in business school. 8. When people know they're being evaluated, they tend to act phony, and there's always tension that what they do could be written up. A law of psychology states that if someone puts an extrinsic reward system in place on something you like to do anyway, it screws you up, your love of the process goes, and it is replaced by worrying about the PER and trying to fit into it instead of just being yourself and trying to do a decent job for the love of it. Enlightened managers have to get over the brainwash to be more intuitive about their lives, listen to themselves and go with the flow, dealing with employee situations as the raise and ignoring them in favor of production when the going seems to be smooth with everyone performing at a reasonable comfort level. Built into any organization is a silent self-accountability code. If an individual is a screw-up and or doesn't pull his weight, nobody else wants it, not the bosses, the other workers or the customers, so the word always gets out sooner or later anyway without the need for PERS, and the players involved deal with it. Either the employees knock some sense the bad seed or get rid of him, or the boss steps up to the plate and deals with it without using PERS. It's just part of the way a normal organization operates. Stated simply, PERS give off a vibe of bad intentions. Employees hate them being dissected, and a lot of managers don't particularly like the process of dissecting their employees just because it's that time of the year again. Guide people along, offer training programs and mentor them rather than give them automatic PERS. Give feedback when and as required. If the employee does a functional job, don't patronize him. Leave him be. If he does a good job, promote him, give him a raise, tell him or give him Friday afternoon off. Tell your employees the truth, that you think PERS are stilted and outdated, and you're gonna be more intuitive from here on in, just dealing with problems and rewards for extra good work when and as required. PER websites. You can find PER information at Human Resources. SuccessFactors.com, employee evaluation, screening tests, and evaluations for sale. CareerCC.com/career_assessment.html. AssessmentGenerator.com. AbolishAppraisals.com. BusinessLink.gov.uk, appraisals help us monitor performance and motivate staff. EPRActizelabs.com, employment screening, assessment testing, employee training. E-valreports.com. Vocationalassessments.com. Chapter 5. Privacy Issues at Work. Privacy Issues at Work 1. The most basic privacy issue at work is both personal information and company information. Generally, the employer has no right to pass employee records around to anyone who doesn't need them in a work-related capacity, nor does he have the right to snoop around in areas not related to the job, which raises the question, to what extent can an employer go to pre-screen employees before hiring them? By the same token, the employee has no business talking about company business to anyone not directly involved in the business. The U.S. Constitution grants us certain rights like freedom of expression, limits on searches and questioning people suspected of crimes. You have constitutional protections from the invasion of privacy into your personal life in matters not relating to work, but your personal rights are compromised when you enter the work arena. When you take on a job, you're implicitly giving some of your freedom and privacy away to your employer, but the question is how much. Whatever they do to compromise your privacy and freedom must be relevant to the job in order to be legal. The line between an employer's right to know what an employee does outside the job and the employee's privacy is a muddled area from a legal and common sense point of view. For legal purposes, to protect himself, the employer should set out what he plans to do if it will possibly violate a person's privacy, such as monitor telephone calls and emails, plans to put surveillance cameras up, or demand urine testing for drugs. The actions must be work-related. They must have a reasonable intent to them. For example, if you plan to put a surveillance camera up on the floor, you say it's to record accidents if and when they happen and to deter theft. If you plan to monitor internet usage, you say you won't tolerate employees not doing work on work time and instead fooling around on the net. If you plan to do things that will compromise privacy, tell your employees before you do them in writing so they know. Be honest with them. Give them the reasons why you're invading their privacy. Tell them straight up that they have no reasonable expectation of privacy on company time. You should have consent forms, or at least acknowledgement forms, which the employees and independent contractors sign. This way they know if there is some kind of surveillance on them. This is called openness, telling your employees what kind of surveillance measures you're using. Tell them you won't be using the information other than for work-related matters. You will not report what websites they surf to their spouses or make it public knowledge. If you're a big company, get one of your human resources people to become the workplace privacy expert and develop a privacy compliance program which will spell out what surveillance actions the company will use and specify what will be done with the information after it is collected. Even if you're collecting employee information such as monitoring his or her email and fax usage, you are still obligated to protect the person's privacy by not letting anyone see this information except for maybe the project privacy manager, PPM, and a relevant manager or two. Get your lawyers to look over your plans. Ask them what the privacy at work laws are in your area. Privacy issues at work 2. The basic issues regarding privacy in the workplace are as follows. Employee pre-screening before hiring. Interview questions. Surveillance, both visual and electronic. Drug and alcohol testing. Third-party information, asking others about the employee. Searching employee locker rooms, vehicles, pockets, clothing, kit bags, etc. Off-duty life of the employee. Who has access to employee records? Medical information obtained by employers not related to the immediate situation. For example, some employers have been requiring employees to give a DNA sample which is then tested to determine genetic predisposition to major diseases, and if the employee is found to have a high genetic predisposition, the company quietly tries to get rid of him. Some companies have been accused of doing this without telling the employees this is what they were doing. They were told the DNA sample was just routine, to run conventional medical tests. By being personal and personable, the employer may think he cares about the employee, wants to relate and help out, but my attitude is if the individual does adequate work, but out unless they come to you with a problem or concern. Don't be too personal. It's work. If a normally good employee seems shaky lately, back off. Mind your own business. Everybody goes through crises. Give them a month or so, and if they're still looking weak, ask them what's going on. There are very few federal laws regarding employment privacy. Such laws, if they exist, are at the state and local level. The general rule of thumb is that whatever an employer does that could be an invasion of employee privacy must have a legitimate, business-related reason. If workers are stealing from you, put surveillance cameras up near the door, but don't put them in the bathroom. Employees file lawsuits against employers for invasions of privacy, so think before you do anything that might go beyond your legitimate need to know for business reasons. Don't give out information on employees to outside organizations unless it's directly related to business. One of the most sensitive areas of privacy is in the area of interviewing candidates for a new job. Keep your questions on the job, not about the personal life of the individual. If you work in an area where there's a lot of money, the boss can legally take measures to protect himself, like check your background out and install cameras there. But if you work in a slaughterhouse, the boss has no justifiable need for these invasions of your privacy. The Labor Management Relations Act covers privacy issues. You have to go the collective bargaining agreement between management and the unions where you work. The Federal Employee Polygraph Protection Act forbids the use of polygraph/lie detector tests for pre-employment screening. Employers can request that you take a polygraph if you're suspected of a crime or in the interests of security only. Polygraph testing law in the workplace differs for every state, totally illegal in some. Genetic testing is another area that's protected by many state laws. A potential employer is not allowed to subject you to genetic testing in the course of a medical examination which may reveal certain dispositions such as sickle cell anemia or cancer susceptibility. Employers are allowed to use video surveillance in the workplace. Some unions demand to be informed of hidden camera surveillance. The Federal Omnibus Crime Control and Safe Streets Act regulates wiretapping and eavesdropping, making it illegal in all situations except if the employee is told in advance that he may be monitored in some situations such as on the phone, email, etc. If the communication is personal, the eavesdropper is supposed to cease listening and only attend to business-oriented correspondence. Searches are only allowed if there's a good reason, such as recent thefts. If you work in certain states or for the federal government under union contract, you have the right to see your personnel files. In some states and companies, you don't have that right unless you're involved in a lawsuit with your employer. Get spyware for your computers like SpectreSoft.com. Tell them you can monitor everything they do on the computer. Tell them their phone calls are being monitored. You have the legal right to do this to your phones on company time. Try hashtag 331.011 or JC596.2 at the library. Privacy resources in general. Books about privacy are at hashtag 323.4 or JC596 and KF1262 at the library. computer.howstuffworks.com/workplace-surveillance.htm. consumer.gov/ID theft. cpsr.org/cpsr/privacy. EFF.org, the Electronic Frontier Foundation. epic.org/privacy, the Electronic Privacy Information Center. ftc.gov/privacy. howtobeinvisible.com. privacy.net. privacy.org. privacyalert.us. privacyfoundation.org. privacyinternational.org. privacyrights.org. privlaw.com, Canada. American Civil Liberties Union. aclu.org. Privacy Rights Clearinghouse. privacyrights.org. Privacy law website / work privacy websites. CSA.ca, Canadian Standards Association. EFF.org, Electronic Frontier Foundation. OECD.org, Guidelines on the Protection of Privacy and Transborder Flows of Personal Data. Privcom.gc.ca, Privacy Commissioner of Canada. tbs-sct.gc.ca/index_e, Treasury Board of Canada's Privacy Impact Assessment Policy. worldprivacyforum.org/workplace.html, World Privacy Forum, Workplace Privacy Project. ScottNScottLLP.com, Privacy Policy Lawyer. hg.org/privacy.html. privacytimes.com. epic.org/privacy/consumer/states.html, Privacy Laws. law.com, State Privacy Laws. Chapter 6. A Legal Internet at Work Guide. Internet at Work. All employers should set up ground rules for employee internet usage and put them in the company manual and/or on the bulletin board. You should also tell them you're monitoring their usage via a security software program like SpectreSoft.com, which records all emails sent and received and records the names of all websites visited in a neat file. Employees expect workers to work while at work and not cruise the internet for personal reasons. This is a reasonable request. If I were a business owner, I would allow the employees to use the internet for personal reasons only on their own time, as with breaks and after work for a short while. I would record usage, tell them I was doing it, tell them the penalty was severe, a $200 fine and 3 strikes, and they were gone. I would enforce this rule by checking on the software and acting on transgressions. I would offer a reward of $100 for anyone who anonymously reported someone they saw using the internet for personal reasons, which means I wouldn't disclose who told me, if anyone. I would just have to go to my trusty software and it would all be there tabulated by time. Another area of internet usage in the workplace that has caused problems is the sexual harassment issue, such as with dirty jokes being emailed around or somebody viewing a porno site in full view of others who don't want to see these things. If it's done on company time with company computers, the company is ultimately responsible. Even though some workers claim it's a privacy issue, that they're being snooped on at work, the legal fact is that you have no real privacy at work except in the bathroom. As a legal safeguard, an employer should state explicitly that employees have no privacy at work and should expect to be monitored. Another point is that in order for the company to protect itself from sabotage in the form of viruses, set up ground rules for downloading information and software from unreliable sources or opening email attachments from people they don't know. Either have them download information only from reliable contacts, come see you with questionable transmissions, or have a separate computer off in the corner not attached to the company network which they can use to send and receive things from questionable sources. Finally, employees are both curious and vindicative, so if you give your employees free rein over the entire company network, they could do some damage if they get mad enough. Set up your network such that employees can't get into valuable information they don't need to do their jobs and damage it somehow. Have a backup system or two in place. A good system which I've used a few times is to have a feature where your computer goes back in time a day or two, so if you have a problem, you merely start up your computer and go back a day to the time before you had that problem, thus avoiding it altogether. Put a clause in the employment contract stating that when an employee leaves the company, he is no longer allowed to access the company website. Render his password void. theinternetpatrol.com/employees-fired-for-fire-the-job. techdirt.com. Cyberslacking/wasting time on the internet. Cyberslacking is workers who slack off at work by cruising the internet for their own benefit at the expense of doing work for their employer. An easy way to solve it is to install spyware that records everything that happens on the computer. Don't tell them you installed it so that you catch the most blatant abusers, then the rest will know you're tracking their computer usage, so they'll stop the frivolous cruising. There is also blocking software that will block websites like game and porn websites and other popular ones. It's a serious problem that costs companies a lot of money and the work doesn't get done in a timely fashion. There is no reasonable expectation of privacy at work. If you're working on company computers, your bosses have every right to monitor what you do. oftob.com/workplace_privacy_cyberslacking main.htm. apluscsystems.com, how to prevent cyberslacking. en.wikipedia.org/wiki/cyberslacking. reference.com/browse/wiki/cyberslacking. getsafeonline.org. buzzfeed.com/buzz/cyberslacking. webopedia.com/term/c/cyberslacking.html. trendhunter.com/trends/cyberslacking. Cyberspying at work. Beware that your bosses at work can install simple spyware software and track every website you surf and every email you send and get. Spyware records which websites are visited on the computers you install it on. This software creates a secret file such that you can view all transmissions on the computer like websites visited, emails, chats, etc. bestspyware.com, monitoring technology that allows you to monitor any PC from anywhere. computercopinfo.com. computer-spy-programs.com. cyber.la.harvard.edu/people/edelman/ads/gator. lavazobtusa.com, spyware removal programs. modemspy.com, this software will record all your phone calls and keep a record of them. securecomputing.com. securetactics.com. Anti-spyware software. Check to see if someone is spying on your computer usage, either someone in your home, your boss, or some internet business that has installed adware on your computer. anti-spy.com. pestpatrol.com. safernetworking.org. spychecker.com. spywareinfo.com. Chapter 7. An Employment Law Website Guide at feedspot.com. A list of employment law blogs and websites at blog.feedspot.com/employment_blogs. aallrr.com/labor-employment-law-blog. akilvalentine.com/blog. allenovary.com/n-gb/global/blog/employment_talk?? pages eyes =7. amglaw.com/blog. atlantaemploymentattorneysblog.com. barryfisher.ca/employment-law-blog. blog.firstreference.com. blogs.dlapiper.com/employment-germany. blogs.oric.com/employment. bowriveremploymentlaw.com/blog. bsk.com/new-york-labor-and-employment-law-report. btlaw.com/n/insights/blog/currents. californiaemploymentlaw.foxrothschild.com. calpeculiarities.com. calpublicagencylaboremploymentblog.com. capclaw.com/blog. constangy.com/employment-labor-insider. crippspg.co.uk/blog/employment. ctemploymentlawblog.com. dcemploymentattorney.com/resources/blog. duttonlaw.ca/blog. eclaw.com/blog. employeeattorney.blogspot.com. employmentattorneylaw.com/blog. employmentattorneymd.com/employment-law-blog. employmentblog.practicallaw.com. employmentlawblog.info. employmentlawhandbook.com/blog. employmentlawlandscape.com. employmentlawworldview.com. fedemploymentlaw.com/blog. fellhaber.com/home/mn-employment-law-report. firstaff.ie/blog. genovaburns.com/publication/labor-law. globalworkplaceinsider.com. greensfelder.com/employment-and-labor-blog, hrlegalist.com, hsfnotes.com/employment, klilaw.com/blog, krevskybowser.com/blog, laborandemploymentlawcouncil.com, laborandemploymentlawupdate.com, laboremploymentlawblog.com, laboremploymentreport.com, laborandemploymentlaw.com, lawandtheworkplace.com, lawfficespace.com, lawgrady.com/blog, lawsonlundell.com/labor-and-employment-law-blog, lawyersforemployers.com.au/articles, leckerslaw.com/blog, lipskylo.com/blog, minkenemploymentlawyers.com/category/blog, New Jersey Employment Law Firm blog.com, ocalaemploymentlawyer.com/blog, ohioemployerlawblog.com, ottawaemploymentlaw.com, overholdlawyers.com/blog, paulzinelliatwork.com, San Antonio employmentlawblog.com, sandbergphoenix.com/perspective/blog/employer-law-blog, scemployersblog.com, shawlawgroup.com/blog, sbigglaw.com/employment-blog, tglaw.com.au/employment-blog, thelilawblog.com, toronto-employmentlawyer.com/blog, vigilant.org/employment-law-blog, washingtonlaborandemploymentblog.com, wongemploymentlaw.com/blog, workforcebulletin.com, workplacelegalpc.com/blog, workplacereport.nslglink.com, wyattfirm.com/blog/category/employment-law-report, zatlaw.com/blog. A list of employment and employment law news feeds at blog.feedspot.com/employment_RSS_feeds. aallr.com/labor-employment-law-blog, aallr.com/labor-employment-law-blog ?RSS, akilvalentine.com/feed, akilvalentine.com/blog, allenovery.com/n-gb/global/blog/employment_talk ? Pages =7, amglaw.com/blog, amglaw.com/feed, atlantaemploymentattorneysblog.com/feed, atlantaemploymentattorneysblog.com, blog.feedspot.com/employment_RSS_feeds, blog.firstreference.com/feed, blog.firstreference.com, blogs.dlapiper.com/employment Germany, blogs.oric.com/employment, blogs.oric.com/employment/feed, bowriveremploymentlaw.com/blog, bowriveremploymentlaw.com/feed, bsk.com/new-york-labor-and-employment-law-report, btlaw.com/n/insights/blog/currents, californiaemploymentlaw.foxrothschild.com, calpeculiarities.com, calpeculiarities.com/feed, calpublicagencylaboremploymentblog.com/feed, calpublicagencylaboremploymentblog.com, capclaw.com/feed, capclaw.com/blog, constangy.com/employment-labor-insider, constangy.com/employment-labor-insider ?RSS, crippspg.co.uk/blog/employment, ctemploymentlawblog.com/feed, ctemploymentlawblog.com, dcemploymentattorney.com/feed, dcemploymentattorney.com/resources/blog, duttonlaw.ca/blog, duttonlaw.ca/blog/feed, eclaw.com/blog. eclaw.com/blog/feed. employeeattorney.blogspot.com/feed/post/default?alt=RSS. employeeattorney.blogspot.com. employmentattorneylaw.com/blog. employmentattorneymd.com/feed. employmentattorneymd.com/employment-law-blog. employmentlawblog.info/feed/adam. employmentlawblog.info. employmentlawhandbook.com/feed. employmentlawhandbook.com/blog. employmentlawlandscape.com/feed. employmentlawlandscape.com. employmentlawworldview.com/feed. employmentlawworldview.com. fedemploymentlaw.com/feed/adam. fedemploymentlaw.com/blog. fellhaber.com/home/mn-employment-law-report. fellhaber.com/feed. firstaff.ie/blog. firstaff.ie/feed. genovaburns.com/publication/labor-law. globalworkplaceinsider.com/feed. globalworkplaceinsider.com. greensfelder.com/employment-and-labor-blog?RSS. greensfelder.com/employment-and-labor-blog. hrlegalist.com/feed. hrlegalist.com. hsfnotes.com/employment. hsfnotes.com/employment/feed. klilaw.com/blog. klilaw.com/feed. krevskybowser.com/feed. krevskybowser.com/blog. laborunemploymentlawcouncil.com/feed. laborunemploymentlawupdate.com. laborunemploymentlawupdate.com/feed. laboremploymentlawblog.com. laboremploymentreport.com. laboremploymentreport.com/feed. laborunemploymentlaw.com/feed. laborunemploymentlaw.com. lawandtheworkplace.com. lawandtheworkplace.com/feed. lawfficespace.com. logrady.com/blog. logrady.com/feed/adam. lawsonlundell.com/labor-and-employment-law-blog. lawsonlundell.com/labor-and-employment-law-blog/?RSS. lawyersforemployers.com.au/feed. lawyersforemployers.com.au/articles. leckerslaw.com/blog. leckerslaw.com/blog/feed. lipskylo.com/blog. lipskylo.com/feed. minkenemploymentlawyers.com/category/blog. New Jersey Employment Law Firm blog.com. New Jersey Employment Law Firm blog.com/feed. ocalaemploymentlawyer.com/blog. ocalaemploymentlawyer.com/blog/feed. ohioemployerlawblog.com. overholdlawyers.com/feed. overholdlawyers.com/blog. paulzinelliatwork.com. paulzinelliatwork.com/blog ?format =RSS. San Antonio Employment Law blog.com/feed. San Antonio Employment Law blog.com. sandbergphoenix.com/perspective/blog/employer-law-blog/feed. sandbergphoenix.com/perspective/blog/employer-law-blog. scemployersblog.com. shawlawgroup.com/feed. shawlawgroup.com/blog. sbigglellaw.com/feed. sbigglellaw.com/employment-blog. tglaw.com.au/employment-blog. tglaw.com.au/employment-blog/feed. thelilawblog.com. thelilawblog.com/feed. Toronto-employmentlawyer.com/feed. Toronto-employmentlawyer.com/blog. Vigilant.org/employment-law-blog. Vigilant.org/employment-law-blog/RSS. wongemploymentlaw.com/blog ? format =RSS. wongemploymentlaw.com/blog. workforcebulletin.com. workforcebulletin.com/feed. workplacelegalpc.com/feed. workplacelegalpc.com/blog. wyattfirm.com/blog/category/employment-law-report/feed. wyattfirm.com/blog/category/employment-law-report. zatlaw.com/blog. A list of employment law news websites at feedspot.com/news/employment_law. constangy.com/employment-labor-insider. Thomson Reuters, Practical Law Employment Blog. employmentblog.practicallaw.com. Employment and Labor Insider Blog. employmentandlaborinsider.com. Herbert Smith Freehill's Employment Notes. hsfnotes.com. The Shepard Mullen Labor and Employment Law Blog. laboremploymentlawblog.com. Employment Law Worldview. employmentlawworldview.com. Fox Rothschild LLP, California Employment Law. californiaemploymentlaw.foxrothschild.com. Employment Law. blog.firstreference.com. Publisher of Canadian Payroll, Employment Law. Dutton Toronto Employment Law Firm. duttonlaw.ca. Employment Law Handbook Blog. employmentlawhandbook.com. Barnes and Thornburg, Employment Law Blog. btlaw.com. Thomson Geer Lawyers Employment Blog. tglaw.com.au. The Spiegel Law Firm, Employment Blog. spigglellaw.com. Minkin Employment Lawyers, Toronto Employment Blog. minkenemploymentlawyers.com. Proskauer's Law and the Workplace Blog. lawandtheworkplace.com. Workforce Bulletin, Insights on Labor and Employment Law. Hospitality Labor Employment Law blog.com. Norton Rose Fulbright Law Firm, Global Workplace Insider. globalworkplaceinsider.com. Daniel Schwartz, Connecticut Employment Law Blog. ctemploymentlawblog.com. HR Legalist, Labor Relations. hrlegalist.com. lawyersforemployers.com.au. A list of labor law websites at blog.feedspot.com/labor_law_blogs. archeremploymentlaw.com. bdl-firm.com/category/labor-and-employment-law-blog. blog.feedspot.com/employment_blogs. bostonlawyerblog.com/category/employment-law. bsk.com/new-york-labor-and-employment-law-report. californiaemploymentlaw.foxrothschild.com. Cal Public Agency Labor Employment Blog.com/category/wage-and-hour-2. constangy.com/employment-labor-insider. denverlaborlaw.com/colorado-employment-law-blog. employmentlawwatch.com. fedemploymentlaw.com/blog. foley.com/n/insights/blog/labor-employment-law-perspectives. genovaburns.com/publication/labor-law. healthemploymentandlabor.com. hospitalitylabor-employment-law-blog.com. laborandemployment-law-update.com. laboremployment-law-blog.com. laborandemployment-law.com. laborlawbox.blogspot.com. lawandtheworkplace.com. lawblogs.ca/category/labor-employment. lexblog.com/site/labor-employment-law-blog. louisianalawblog.com/category/labor-and-employment-law, micalaborlaw.com, paulabiorandemploymentblog.com, retaillaborandemploymentlaw.com, stoelrivesworldofemployment.com, swlaw.com/blog/labor-and-employment, thelilawblog.com, thenjemploymentlawfirm.blog.com/category/new-jersey-labor-law, uaelabors.blogspot.com, wyattemployment.com/category/uncategorized/labor-law, blog.feedspot.com/labor_RSS_feeds. Chapter 8. Alternative Dispute Resolution and Mediation. Conflict resolution at home and in business. Spouses and families fight and people in business fight. Here are some websites to help you resolve conflicts. The key is to give a little bit and compromise. Try not to start off with a negative attitude. Don't go in half-cocked looking for a fight or to unload on someone. You can't beat around the bush. People can't read minds. You have to approach the other person and state directly that we have an issue we should try to resolve together. Try to be cooperative. Identify/define exactly what the problem is without criticizing a person. Try to resolve it being curious and friendly rather than oppositional. Just say we've got an issue we should try to solve. Don't bring the police or a lawyer into it unless personal, face-to-face measures fail. acrnet.org, acresolution.org, the Association for Conflict Resolution. acresolution.org, Association for Conflict Resolution. Mediation and Arbitration at Work. If you're in an employee-employer employment dispute for breach of contract, unjust termination, or any other matter, rather than go through the courts, you can go through mediation or arbitration. In mediation, the mediator is a neutral third party. In collaborative law, it's just the two sides talking it out with no third party present. Mediation and collaborative law are generally agreed to by both sides together. In arbitration, the arbitrator makes the final decision just like a judge does. The mediator could be a lawyer or a professional in the social work/counseling field. It is much cheaper than using lawyers, and lawyers don't particularly like it. Mediation at Work websites. mediationworks.com, adrforum.com, National Arbitration Forum, transformativemediation.org, acjnet.org, Access to Justice and Work, afccnet.org, Association of Family and Conciliatory Courts, mediation.com, mediatorindex.com, nicar.ca, Network, Interaction for Conflict Resolution Canada, nocourt.org/principles.htm, Collaborative Law, American Arbitration Association, 800-778-7879, Fax, 877-INFO AAA, adr.org. National headquarters of this nonprofit organization with 37 regional offices. Divorce mediators available. Association for Conflict Resolution. 1015 18th Street NW. Number 1150 Washington, D.C. 20036. 202-464-9700. acrnet.org. Association of Conflict Resolution. 1527 New Hampshire Avenue, NW. Washington, D.C. 20036. 202-667-9700. Mediate.com. Alternative Dispute Resolution/ADR. Instead of going to court on a civil matter like a divorce, a business disagreement, a consumer problem, a landlord-tenant issues, etc., you might be able to resolve a civil problem or dispute by simply talking to the complainant, or you may both agree to a formal proceeding commonly called an alternative dispute resolution/ADR. These kinds of legal processes can be used in almost all kinds of civil cases, including employment, business dispute, family, divorce, neighbors, landlord-tenant, consumer, personal injury, home improvement services and contracts. There are several different types of ADRs. The spirit of all of them is that the two sides sit together with a neutral third party who will either act as the referee or the judge, depending on the type of ADR the players choose. In order for there to be an ADR as opposed to a court case, both sides have to be open and friendly enough to agree to this arrangement and agree to abide by the results. They are still adversarial but willing to give a little bit more than in a court case. Depending on the laws in your area geographically and in the subject area of your dispute, there could be provisions in the law that allow you to choose ADR instead of a regular court case, or you could operate independently of the court system if you want. Before you file a lawsuit, ask the other side if they would be willing to go through an ADR process rather than go to court over it. The biggest advantages of ADR over litigation are: speed of resolution, cheaper costs, no lawyers getting high fees for an extended period of time. With ADR, if it breaks down or you don't like the way it's going, you can always revert back to the court trial process if you want. The general procedure is as follows. Both sides agree to an ADR process. The two sides write an agreement where they agree on the time, the duration of the process and who, if anyone, will make the final decision. Sometimes, but not all, each side will write up their version of events to give to the arbitrator/mediator. There will have to be an agreement to how the arbitrator will be paid and possibly a constraint on time. Both sides could agree that the process will go on regardless of time constraints or agree to X number of hours for the process, then that will be it. Either they or the arbitrator will have to make a decision after that. On the day of the meeting, each side will come in. The moderator will explain the case briefly by defining the exact issue at hand and give each side a chance to make their presentation. After this, they will discuss, argue, and negotiate until either they reach a mutual decision, or if they can't, the moderator will say he has heard enough and goes off to deliberate about his decision. This could take several days. The moderator's skill is in being neutral while being civil and friendly to both sides. His job is to help each see the other side, to prevent them from fighting and keeping a level head so that both sides stay to work through it. He can inject his ideas about how the two parties should resolve the issue at hand. The moderator has the option to talk to each side in private if he wants, in order to help him resolve the issue at hand. If one of the sides doesn't like the way the proceeding is going, they can cut it off before the final decision and revert back to the court litigation process. In big cases, several people sit on a board of arbitrators or mediators and hear a case as a team. Think of the moderator as a judge, referee, teacher, and ideas person. Think of ADR as good faith bargaining. Negotiation. The simplest type of ADR is a negotiation process. Both sides try to work it out. They try to hammer out a deal together by talking it out while a third party tries to help them with general advice. You have to give a little bit and compromise. Each side states its terms, then you discuss them anywhere from a few minutes to several days and end up with an agreement. Mediation. Mediation is a good faith process with both sides presumably entering into it to come to a fair settlement. If one side is in stronger or bullying position, mediation is no good. If one side wants punitive damages, the issue has to be resolved in a court of law. The mediator must be someone who does not have an emotional or financial stake in the outcome. Mediators should be professionals who don't know the players involved. The mediator's job is to sit with the players and try to keep them calm and cordial while you all work on solving the problem you're working on. A mediator schedules a meeting at a time and place convenient to everyone. He wants them all to feel they can speak openly and makes it clear that his job is to get to the bottom of the problem. The mediator gives the players turns explaining their position, issues, or feelings. Make a rule that they are not to be interrupted while speaking. Have someone take notes. Encourage questions by the other side after one side has spoken. Periodically, with a complicated point, have the note-taker read back what someone said such that the person can either confirm or clarify it. Invite everyone to offer their own solutions. Discuss these possible solutions. Try to come to a solution that everyone can accept. It will usually be a compromise, each side giving a little bit. The ideal is to let the people experiencing the conflict decide on a solution among themselves without input from the mediator. If they can't, then the mediator has to make that decision for them. Tell them that you would rather that they come to an agreement amongst themselves rather than you making it for them. Once you reach a solution, tell them you'll put it into practice for a week or two, then call another meeting to discuss it and make adjustments if necessary. The mediator is more a moderator than a judge. He's controlling the flow of discussion between the two parties. His job is to keep them talking until they come to a decision together. If the talks break down, they can choose to go back to court to settle the problem. The proceedings are informal, and although you can bring a lawyer, it doesn't seem appropriate because of the good faith nature of the process. Arbitration. Arbitration is a process wherein if you have a beef against anyone regardless of whether it's business, a landlord-tenant dispute or any civil matter, you can take it to arbitration rather than to a court where an arbiter, who is less stringent than a judge, will hear your case and the decision he or she makes will be legally binding. The advantages of arbitration are generally less formality than a court trial, less expensive and less time-consuming. The difference between arbitration and mediation is that in arbitration, the arbiter generally makes the final judgment, whereas in mediation, the mediator tries to get the parties involved to reach some kind of agreement amongst themselves. The tendency of alternative dispute resolutions is that the arbitrator will typically try to satisfy both parties and split the case down the middle rather than a court case, which usually ends up with a winner and a loser. Both sides agree that the arbitrator, a neutral third party, will make the final decision that will be legally binding. This process is more formal than mediation, and both sides can bring evidence and witnesses in and also use lawyers in the process. This sounds a lot like regular trial, but it differs in that the arbitrator is much more flexible about not having to follow the procedure of law and can use evidence not normally accepted in a court of law, like hearsay. After the hearing, the arbitrator deliberates and delivers a written decision within 30 days, and that's it. There's no magic verdict moment, it's a piece of paper. The decision of a binding arbitration is final and you can't appeal it. Also, you can't use a jury as in a regular trial. Summary. Both mediation and arbitration are private, unlike public courtroom trials. There are alternative dispute resolution centers all across the country. Check the yellow pages of the phone book under the following categories: alternative dispute resolution, arbitration, mediation service. Also, refer to your local Better Business Bureau, which does a lot of arbitration and mediation work in consumer affairs between customers and business owners. They also help a lot of unhappy car owners get satisfaction from the dealers. In the final analysis, if you think it's a viable option in your case, consider mediation/arbitration in lieu of a court trial. There are books about ADR at #347.710-740 and K8615 or KF9084 at the library. ADR websites. Contact one of the following organizations or the trade organization in the area you're disputing: ADR.org, American Arbitration Association; CEDAR.co.uk, Center for Dispute Resolution; ConflictResolution.org; CPRADR.org, CPR Institute for Dispute Resolution; Mediate.com; Mediation.org, Academy of Family Mediators; Mediations.com; No-faultadr.org, New York; American Bar Association; Standing Committee on Dispute Resolution; 740 15th Street Northwest, Washington, D.C. 20009, 202-662-1680. Abanit.org/public. Will help you find a resolution program to deal with a consumer problem. Better Business Bureau, 4200 Wilson Boulevard, number 800, Arlington, Virginia 22203, 703-276-0100, 334-2406. bbb.org. Dispute Mediation Organization. 800-3520527. 800-400-3773. jams-enddispute.com. National Arbitration Forum. 800-474-2371. arb-forum.org. National Institute for Dispute Resolution. 1901 L. St. N.W. Number 600. Washington, D.C. 20036. 202-862-0100. 202-466-4764. crenet.org. Public Investors Arbitration Bar Association. Norman, OK. 888-621-7484. 404-365-0150. paba.org. Will recommend a lawyer for arbitration. Mediation organizations in Canada. afcnet.org, Association of Family and Conciliatory Courts. amici.org, Arbitration and Mediation Institute Canada. attorneygeneral.jus.gov.on.ca/html/family/familymediation.htm, Ontario Mandatory Mediation Program. ccmmediation.com, Canadian Centre on Mediation. mediation-services.ca. Arbitration and Mediation Institute of Canada. 232, 329 March Road. Box 11. Canada, on K2 times 10 to the power of first. 877-475-4353. 613-599-0878. Fax, 613-599-7027. amici@igs.net. amici.org. Canadian Bar Association. Task Force on ADR. 902-50 O'Connor St. Ottawa, on K1P6L2. 800-267-8860. 613-237-2925. 613-237-1988. Fax, 613-237-0185. info@cba.org. cba.org. Contact them for a referral to a mediation program in your area. Center for Mediation. 2300 Yonge Street. Number 709. Toronto, on M4P1 times 10 to the power of 4th. 416-544-0633. Fax, 416-544-0631. Family Mediation Canada. 123 Wallach Street. 2nd FL. Guelph, on N1H3B1. 519-836-7750. Fax, 519-836-7204. fmc@web.net. fmc.ca.